Good morning and or good afternoon, depending on where you are logging in from across the country here. Um, you have joined the Immigration Law Updates to 2025 Outlook panel. We are the one immigration panel within the bevy of labor and employment topics that are being presented today. The immigration group, sorry, first I should introduce my partner in crime, which is Shannon Houston, who also does immigration here with me. We are a small but mighty group within the immigration, within the Miller Thomson here that does immigration, business immigration mostly, going into the US as well as going into Canada. Um, we are, I guess, a subset of the labor and employment group, arguably possibly the better looking set of the labor and employment group, but there's nobody else here to argue with me on that one, so we'll go with that. Before we start, I have a few housekeeping items that I've been asked to read. Number one, because of the number of participants that we have, you've been placed on mute. Just because of the sheer number of people that are within this panel here. If you do have questions, please send them in. Unfortunately, we won't have time to respond to those questions during the session, but my understanding is that those will be forwarded to us afterwards, and then we will do our best to respond to as many as we can. If you do need technical support, I understand that there is a help button below the video window right next to the return to agenda button that you see on your screen. And lastly, the standard caveat, which is the presentation is for informational purposes only and does not constitute legal advice. Please contact one of the lawyers on our immigration group for guidance on your specific situation. So today we're mainly talking about the numerous changes that have come about in Canadian immigration laws over the past year and a half, almost 2 years now. Shannon and I were talking about a little bit about it at the beginning, and we have to acknowledge that unfortunately this is perhaps a little bit drier on the drier side than our typical presentations, mainly because there have been just so many changes that have occurred over the last year and a half, 2 years, that we just wanted to be able to list them and summarize sort of how that potentially will affect employers and companies in their employment of foreign workers. But going on to then with regards to the agenda, we will, if we could forward it to the agenda slide. Those are our beautiful faces. There we go. So the agenda, I will be talking about the topics basically 1 to 4. Obviously, just by that, you can tell that Shannon's got the heavier load here. But we'll be talking about sort of just some basics. We tend to use a lot of different acronyms or terms within immigration, so we want to make sure that everybody understands specifically what it is that we're talking about when we are using those terms and those acronyms. And then mainly I'm going to be talking about the changes that have come about relating to the temporary resident category. So the people that are here on a temporary basis, as opposed to people who want to actually immigrate and stay permanently in Canada. So we'll just get right into it with regards to the immigration basics with the next slide. Just a few sort of terms, right? So in immigration, we basically have 3 types of status. We have the citizenship status. These are people who carry Canadian passports or potentially were born in Canada or were naturalized as Canadian citizens. Those are Canadian citizens. Those are the people who can vote within our country. The second status are Canadian permanent residents. Those are the people who are allowed to stay permanently, as it is in the term. They're allowed to stay, live and work permanently in Canada. They carry typically a permanent resident card that the card expires within 5 years, but their status doesn't. So it's just an indication that they are in fact permanent residents, but they can't vote and they don't carry Canadian passports. And then the third category, which is the temporary residents, that's the one that I'm mainly going to be talking about. And basically, those are the people that are here on a temporary basis. Temporary could mean anywhere between, say, just a few weeks or a couple months to up to, say, 3 years, 4 years. But in the end, it's still temporary. There's still an expiry on their status. So if they don't do anything to extend that status in the meantime, they presumably are going to be expected to leave. So when it comes to temporary residents, we are mainly talking about people on study permits, students, workers, people with work permits, and visitors, people with visitor records, who are here in Canada on a temporary basis. Because we mainly deal with, oh, next slide, please. Because we mainly deal with business immigration here at Miller Thomson, there are basically two types of work permits in Canada. We have those that are based upon a labor market impact assessment, an LMIA. You may have heard of it. It used to be called an LMO many years ago, but that's the program where employers are typically expected to do a test of the labor market to show that they cannot find suitably qualified Canadians or permanent residents for a particular position. That's the temporary foreign worker program. The people that are being brought in under that program are called temporary foreign workers. And then we have all the work permit categories in Canada that are not based upon LMIAs. Those are ones where the individuals are allowed and companies are allowed to basically directly support or apply for work permits in Canada. They don't have to do a test of the labor market. They just have to meet the specific requirements that are associated with any particular category. And those are all sort of grouped under the banner of the International Mobility Program, which is really just a term for all the non-LMIA based work permits. To make things just a little bit more complicated, the people that are under those categories are called foreign workers. So they're not temporary foreign workers, even though they're here on a temporary basis, they're just called foreign workers. And then we just refer to them as that. Okay, and next slide, just a little bit of stats with regards to maybe an indication of why some of the changes have come about. The general trend has been that over the last several years has been that I would say just before the pandemic and during the pandemic, a lot of the programs just became more open. The government had implemented policies to facilitate work permits, making it easier to apply for work permits, making certain categories more attractive. At some point, they expanded the ability of people who were here on study permits to be able to work without limits. So there was sort of that type of a trend where it was just everything was just more open and more facilitative, if you will. And now it seems like in the last year and a half, they're sort of trending in the other way. Not super dramatically. And, a lot of people might have heard, oh, they're going to shut down the temporary foreign worker program. Such that hasn't happened, but they are making certain things more restrictive. They are reducing numbers in terms of targets that they're trying to meet in certain categories and such. So it is definitely, of all the changes that we're going to be telling you about today, generally the common theme is that they are making things more restrictive, both for people who are here on a temporary basis as well as for permanent residents. So if we could go to the next slide, just some stats there in terms of the targets that Immigration, Refugees, Citizenship Canada, IRCC, has announced that they are hoping to meet or are planning to meet in terms of the number of work permits, study permits, visitor records that they plan to issue in terms of targets over the course of certain years. And the general plan is to reduce the numbers that they are going to issue. Same thing for the permanent residents as well, is that they plan to make it more restrictive and just simply issue less permanent residency grants over the course of the next few years. And next slide. So getting into some of the key changes now with regards to temporary residents. I think some of the ones that have been affecting the most employers recently, which ironically isn't actually with regards to work permit holders, but it has to do with the study permit holders. So they're reducing the number of study permits generally that they plan to issue, but also they have reduced or they have I guess, reduced from previously the number of hours that a person on a study permit can work while they're here studying on a full-time basis at a designated language institution. So at one point, a person who was holding a study permit in Canada could work up to 20 hours a week while they were in classes, and they could work, and there was unlimited hours that you could work while they were on their breaks, as long as they were still enrolled on a full-time basis. But now and then at some point they expanded and said, oh, you can work as many hours as you want whenever during the course of your study permit. And now they have reduced it back to 24. So it's a little bit better than the 20, but definitely more restrictive than the unlimited amount of time that they previously could work while classes weren't in session. They also made it more restrictive in terms of which schools could actually support study permits, the designated language institutions, which you can find online, as to which ones can support work permits. They also reduced the number of schools, and they also sort of implemented additional, I guess, checks and balances or requirements where you have to also get a provincial letter to confirm that that is a designated language institution that can support the study permit as well. And next slide, please. And then as an extension on the changes to the study permits, one of the bigger changes has to do with the postgraduate work permits. So previously, someone who had graduated from usually a post-secondary institution, a designated language institution in Canada, who had a study permit, could immediately and automatically apply for, and would be eligible to apply for a postgraduate work permit, essentially an open work permit to work in Canada. That is no longer the case. Just because you graduated from a program in Canada doesn't mean that the person is automatically or eligible to apply for a postgraduate work permit. First of all, the person has to have graduated from a designated language institution, but they've implemented additional requirements. If you graduate from a bachelor's, a master's, or higher program, there's language requirements. The person has to submit it with a language test. And then those who are graduating from programs that are not at the bachelor's, master's level, there are additional requirements. There's restrictions where certain people just can't apply if they didn't graduate from certain programs of study. So generally speaking, again, it makes it much more restrictive. Not everybody who graduates with the study permit can now apply for the open work permit that used to automatically ensue after someone graduated from their program. Next slide. Some of the other changes to the temporary resident categories, we have the changes to the people who are spouses of study permit holders. Previously, if a person was a spouse of a study permit holder, they would automatically be eligible to apply for an open work permit. That is no longer the case. Now it is only open to people who are where the primary study permit holder is completing a graduate program, so master's or higher program. There's also, I'm going to jump to the last bullet there because it's also about spouses. So spouses of work permit holder, there's also been changes to that too. It used to be, again, that if a person had a study permit, their spouse would essentially be automatically eligible to apply for an open work permit as well. That is no longer the case. The person who is the primary study permit holder needs to be working at a certain skill level in their position. Basically, it needs to be of a managerial executive level or a professional level. Typically, positions that are associated with jobs that require at least a bachelor's degree. Only spouses of people who are working in those types of positions are able to turn around and apply for their open work permits. Then there's been some pretty dramatic changes with the labor market impact assessment programs, the LMIA, the temporary foreign worker program as well. They've now made it, well, I think the first thing that they did was I think Quebec started it first, but they started restricting the type of situations for which people could even apply for LMIAs, sorry. So it wasn't just so that they were going to reject them, it's just they weren't going to even see them. It's a refusal to process. So Right now, as we're sitting here, the restrictions relate to positions that are considered to be under the low wage category, so under sort of the provincial median wage, and that are located in places in Canada. They call them metropolitan centers, but basically areas in Canada that have an unemployment rate of 6% or higher. So if the employer is paying below that provincial median wage, and or they are in one of those metropolitan areas where the unemployment rate is 6% or higher, you can't even apply for the LMIA. They're just not they're not taking those applications right now. That may change at some point. They may reopen up that category, but for the time being, they are not accepting those types of LMIA. So there's no point in doing the advertising. There's no point in submitting it with a fee or whatever. They're just not taking it. Then there was also a change to the way in which you do the advertising for the LMIAs as well, where basically they implemented a function where they would be able to better track applicants to the job bank ads, and where you would have to respond to certain applicants who do respond who do not necessarily apply, but respond to the job bank ads as well. Okay, and then I think with the next slide, flag polling. So I'm not sure if people necessarily know what flag polling is. That's sort of the term that we've been using for people who are visa exempt, so they don't need visas to come to Canada, and who could apply for work permits or new extensions of work permits and such directly at the border. So generally speaking, for people who are visa exempt and they're here on a work permit, for example, they had two options to apply for an extension of that work permit. They could submit their application online to the Case Processing Center in Edmonton for Immigration, Refugee, Citizenship Canada, IRCC. Right now, I think the processing time is about 191 days. I think I checked it earlier this week. So it's a lengthy process, but that was one way that you could extend your status. The other way for visa exempt people to extend their status or change their work permits would be to simply go down to the border and come back in, and to make their application when they were re-entering Canada. That process is no longer available in many situations. Not all situations. They've left certain situations open, but that whole idea of driving down to the border, going around the flagpole, hence the flag polling term, and coming back to submit their new applications is no longer available for many people. So it's still available to people who are applying under the CUSMA and some other categories, but for many people who otherwise that's how they've been renewing their work permits, can no longer do that. You have to submit your application directly to the Case Processing Center. I've got on the next slide, we have the exceptions to the flag polling ban, if you will. But generally speaking, most people can't do that flagpole. They can't just drive around the flagpole and come back. Now, there are ways to sort of, I'm not going to say skirt around them, because we don't want to make it look like we're sort of encouraging people to do that, but there are exceptions, right? So it's not considered flag polling if you fly outside the continent and come back. If you fly to Europe and then you come back, even if it's like the next day, that's not necessarily considered to be flag polling, and that would be allowed, and they would adjudicate the work permit when it's presented upon return. And then I think that's it for me with regards to the temporary resident changes. So I will flip it over to Shannon.
Sorry about that. Thanks, Veronica. So we're moving on to employer compliance. There hasn't necessarily been a lot of changes. If I could just get the next slide here. There hasn't been a ton of changes in employer compliance over the past few years, but it is a very critical part of both temporary foreign worker program as well as the international mobility program. It's important for you to know that your foreign national employees are all they are all eligible and follow to the same employment laws as your Canadian citizen and permanent resident employees are. In the slide here, you see the regulation that says that you are committing to ensuring that you are employing someone who's allowed to be employed and doing your due diligence to make sure that they're authorized to be employed. Due diligence means a couple of different things depending on what we're looking at here. So it often will require regular check-ins with your foreign national employees to make sure that their work permit is still valid or that they're on maintained status and their maintained status is still valid. If you don't know this, then if you check with your payroll department, anybody that has a social insurance number that starts with the number 9 is a foreign national employee, and that's somebody that you need to be checking with to make sure that their work permit is still valid, or like I said, that they have valid maintained status. Moving to the next slide. Like I said, there's employer compliance under both the Temporary Foreign Worker Program and the International Mobility Program. The programs are separate and they're managed by separate departments, but they're similar in a lot of ways. Historically, under the compliance piece there's been more emphasis on the Temporary Foreign Worker Program and making sure that employers are following all the conditions that they committed to in their LMIA application. Those requirements include the wage that you're offering, as well as the hours of work, benefits, duties, the job location. For low wage LMIA employees, they have to have the employment agreement as well as the flight to and from their home countries is required to be paid for by the employer. And of course, under all of this, employers are not allowed to charge or recover any kind of recruitment fees or fees for an LMIA or anything like that. Something that is not new in the last few years, but new in general, probably since just around COVID, is that employers are required to provide private health insurance from the term when the employee first arrives in Canada until their provincial health care kicks in, because some provinces have a waiting period or a grace period, and you need to make sure that they are covered in that period of time. Moving on to the next slide. Foreign worker or employers under the Temporary Foreign Worker Program are required to complete an employment agreement and make sure that they give the employee a copy of that agreement on or before their first day of work. There's also a pamphlet online that the Temporary Foreign Worker Program has. It's something similar called to Know Your Rights, or making sure that temporary foreign workers are aware of their rights as employees in Canada. You're required to provide that to them before they start, as well as make it available regularly, which might be posting it in a break room or lunchroom, or putting it on a company intranet and making sure that they know that that's always there for them to access and review. You're also obviously required to make sure that they have access to healthcare services in case they get injured or sick while they're at work. And so then just moving on to the next slide, it's a little bit more information about that pamphlet is available, like I said, on the Temporary Foreign Worker Program website. It's available in French and English, and you'll want to make sure that you provide that to them, because in your compliance review, if you are selected, you'll be required to show proof that you provided that pamphlet to them. For the LMIA applications that were submitted since January 1st, 2024, employers are now required to review the prevailing wage rates that are posted on IRCC's job bank. The prevailing wage rates are regularly updated around November or December each year. And if that prevailing wage rate increases, even if you already have an approved LMIA, you are required to increase your your temporary foreign workers wage rate to that new prevailing wage rate. So for example, if the prevailing wage rate that you had approved on your LMIA was $17 per hour, and you go and check it and it's been raised up to $19 per hour and you were only paying $17 per hour, you are required going forward to pay that person $19 an hour with the new wage rate. we recommend, because they do these updates with the wages around November, December each year, we recommend reviewing them each year, making sure that they're on the website. It states when it was most recently updated. Make sure you're looking at the most recent update, and then you need to look at the LMIA approvals that you have and the wage rates that are there to make sure that you are still in compliance with paying them at or above the prevailing wage rate. If the prevailing wage rate decreases, you are not permitted to decrease their wage rate. You just have to make sure that you stay above what the prevailing wage rate is in the LMIA. But moving on to the employer compliance for the International Mobility Program. So that'd be the next slide. Before submitting, I think Veronica detailed a little bit about this at the start. Before you submit an LMIA exempt work permit under the application under the International Mobility Program, employers are required to submit an LMIA exempt offer of employment through IRCC's employer portal, which is an online system. It's called an offer of employment. It's a terrible name, and it confuses everybody because they think that that's an offer letter or something like that, but it's not. It is separate, and it is in this submission that you are committing to or confirming the details of their employment. So this submission will include the wage rate that you're going to be paying them, their job title, their job description, their benefits, their vacation, all of that detail. If you are selected for a compliance review, you will have to provide documentation proving that you are paying them what you said you would be paying them and that they are doing what you said they would be doing. That in the International Mobility Program, again, you're required to give them an employment agreement on or before their first day of work that stipulates all the same terms and conditions of their employment that is stated in the LMIA exempt offer of employment, and it needs to be signed by both the employer and the foreign national. There's also a pamphlet for the International Mobility Program. It is slightly different from the Temporary Foreign Worker Program's pamphlet. It's available on IRCC's website, and you are required to provide that to them before they start employment, as well as, just like with the Temporary Foreign Worker Program, make it available through the regular course of employment, whether that's through a company intranet or what have you. Moving on to the next slide. You're also required to provide access to healthcare services if they get sick or injured at the workplace, just like you are for a temporary foreign worker. And having an abuse-free workplace policy is important. When you get a compliance review or an audit, as we often call them, from the Temporary Foreign Worker Program or the International Mobility Program, you'll be sent a form, and the form will say which employees are being reviewed or audited and the specific date period of employment that they will be looking at. You will then have to pull payroll records, pull employment agreements, pull all of that information and provide them with that documentation to prove that you're doing everything that you said they were going to do and that you're making available everything that you said you would make available, such as the pamphlets, the abuse-free workplace policies, what you're doing to protect your workers in the workplace, essentially. The officers that work with you through these compliance reviews, they normally are pretty good with going back and forth and making sure that you understand everything that they're looking for in the policy. So they are helpful, but you just want to make sure that you remain compliant, which is why it's so important that before there are any changes to anyone's employment that is a foreign national, that they check with the HR people or with legal counsel to make sure that those changes are still in line with what has already been approved. If they're not, then you may have to look at getting a new work permit for that person or a new LMIA if they're under the LMIA program, and then a new work permit before those changes come into place. And that includes wage increases, even slight title changes or slight description changes. If it changes the NOC code, the occupation code that the position falls under, it could require a new work permit and, like I said, a new LMIA altogether. So it's really, really important that you stay on top of your foreign national employees and the terms of their employment are reviewed regularly. So that's it for employer compliance. We're going to move on to the next slide for the changes to the PR programs. There have been significant changes through PR programs. As Veronica mentioned at the beginning, they've significantly reduced the number of spots available for permanent resident approvals or permanent resident applications, which has just made everything slower and harder. The biggest change through the federal permanent resident programs is through express entry, and that's the fact that they eliminated the arranged employment points that are available. So previously, people were allowed to, or they were able to be issued points under express entry for having a job offer that met certain requirements that got them either 50 points or 200 points, depending on the occupation code that they were applying under. That made it so that there were a lot of people that the only way they were going to get to be invited to apply for permanent residence was if they had those arranged employment points. And because of that, there was some mistreatment of the program. There were foreign workers that were coming to their employers and demanding certain things in order for them to be eligible for those arranged employment points. People that were on open work permits were not eligible for them because they didn't satisfy the job offer requirements. So it was really for employer specific people. So it made it really difficult, which is why the government eliminated those points to try and deter the misuse of the system. They've said that this is a temporary change, but we don't know for sure when or if those points are coming back. Something else that they introduced after COVID with express entry is the category-based draws. They're now prioritizing people who speak French and have a certain level of French proficiency and will be living outside of Quebec. They've also prioritized occupations that are in healthcare and social services, STEM occupations, trades, agriculture and agri-food, and education. What's really important to remember with these category-based changes or categories-based draws is that it's not about the company that you work for, the industry, it's about the occupation code that the person is applying for PR under. So even if it's a tech-based company or a tech company, a software company, or anything like that, just because the company itself may fall under STEM, if the job isn't a STEM job, if it's a sales job, if it's an HR job or a marketing job, it's not going to fall into the STEM category draws. So that's something that has come up in the past, and it's really important for employers to know that just because you might be in the industry of agriculture doesn't mean all the jobs or that people are applying for PR are under, or is going to fall under that category. The other pilot programs that were launched recently, only 2 of which are still open, one of which is still open. So the home care worker pilots and the agri-food pilot opened and closed very quickly. Their quotas were met almost immediately once they were open. And so the agri-food pilot was obviously for agriculture, agri-food manufacturers, certain occupations. Most of them were in rural areas as well. And then the home care worker pilot's likely not applicable to many of you, was obviously for childcare and home support workers. The one that is still open is the rural community and the Francophone community pilots. Both of these pilot programs have designated communities that are involved. The rural community pilot has 14 designated communities across Canada that are currently eligible. People are required to get job offers from a designated employer in one of those designated communities. And obviously they're all more remote communities versus the larger city centers. For the Francophone community pilot, it's also a rural-based pilot project. There's only 6 Francophone communities that have been designated so far, and they also have designated employers within those designated communities in order for people to qualify for their job offers through those programs. Moving on to the provincial nominee program is the next slide. So we're mostly just going to be talking about the 3 that we deal with mostly here, and that's Ontario, BC, and Alberta. There have been some big changes. The big changes generally across the board, obviously, is that they've been cut in half for 2024, 2025. We've dropped down to only 55,000 invitations or permanent resident applications that are available, or nomination certificates, sorry, from the provincial nomination program. And that in and of itself, reducing BCs down to just 4,000 has just led to delays, and they're trying to clear their backlog of all the people that they got, they gave invitations to apply to in late 2024. They've experienced longer processing time, and they're already anticipating a higher quota, or hoping for a higher quota in for 2026. We don't know for sure if that's going to come through. The BCP&P program itself hasn't changed significantly. It's mostly just the numbers of that people are having available for approvals. The next slide, please. We're going to talk about the Ontario Immigrant Nominee Program. I would say OIMP has had the biggest changes in the past year. They've done away with their employee-led process, where if somebody had a job offer, they could have put an expression of interest profile in. It's now an employer-led process that must be done through the employer portal. This started in July, and anybody who had an expression of interest in the system before that, under the job offer programs, was immediately removed. They had to be put back in under the employer portal. They couldn't do it themselves. So that was a big change in July. We had lots of clients reaching out for help, and still do, to get people back into that system. Ontario's nominations have dropped by half. So that again has just made everything take longer. There's more targeted invitations that have been, although they haven't been doing very many invitations because they have half the nominations available. The targeted invitations have been for healthcare and early childhood educators and regional streams. They also launched their own rural pilot project in Ontario. So there were 4 communities that are eligible, and they have 200 nominations each. The 4 communities are Thunder Bay, Sarnia, Lambton, Lanark County, and Leeds and Grenville. So those communities get extra OIMP support in order to target more foreign national talent into those more rural areas. Moving on, the last one I want to talk about is the Alberta Provincial Nominee Program. Next slide, please. So in February 2024, they paused this program completely while they were readjusting things. It was paused until June 2024. Now they are doing monthly application intakes for certain streams, each one at a time, and they each have their own targets. It's not on the slide, but the government of Alberta was given their targets were halved. The spots were halved just like everybody else, but they also received a few extra spots after they were halved. So instead of the 4,875 spots, Alberta ended up with 2025 for 6,403 spots, making it a little bit easier on the Alberta Advantage Immigration Program. In April, there was a big fee increase. So with all of these PNP programs, it's an expression of interest that you submit a profile, and then once you're invited to apply, you submit your application to apply. For any of the worker streams, the fee for that second step where you're applying for the provincial nomination has a $1,500 fee now in Alberta. And they've also discontinued the family connection stream and the occupation in demand streams through express entry. The family connection stream obviously had to do with people that had a family member in Alberta who was 18 or over and was a Canadian citizen or a permanent resident already. They were being prioritized for a certain period of time, but they have now stopped with that project completely. Moving on, just a couple of looking ahead things. The next slide. The rest of 2025 is we're seeing a clear evolution in Canada's immigration approach, and we're looking more at priorities in the economic streams and capacity constraints. I even saw a headline earlier today that said the population growth had been stagnant. We'd say it's probably going to be modest or a slight decline, and that's because of the reductions in permanent resident and temporary residents that the government is bringing in. At the same time, we're focused more on the economic immigration. Just moving on to the last slide, what does this all mean to you? It means your foreign national employees need to be aware that there's more competition, stricter criteria, and there's less pathways available. For you specifically as employers, you need to strategize and you need to plan ahead for those key people that you want to keep. That might mean conferring with immigration specialists, immigration lawyers, to make sure that you have a plan in place. It's probably going to take longer to keep them. It might require a few open work permit applications and such, but we are here to help. Thank you so much for attending. You'll now need to return to your agenda to choose your next session. If you have any questions, please reach out. Our contact information is available in the agenda.